Professor Lovemore Madhuku, and he is member. Prominent lawyer Professor Lovemore Madhuku, and he is member of NCA party, submit a fresh constitutional court bid to nullify Mnangagwa's CAB3 and the so-called 2030 agenda. Kusangana kwa taicha zvakare pano pachano yenyu zuva ranhasi musi wa 23 July 2026 patiri kubata nhau dziri kuitika munharaunda nemunyika yedu yeZimbabwe, tichiti kana uri wekutanga kusvika pano paMagaba News ndiwo mukana wekubaya button rakanzi subscribe. Today we have a news dziri kutendera dziri kuziviswa kunzi NCA, member were a political movement inonzi National Constitutional Assembly, inova iri yava Professor Lovemore Madhuku, ine a member weko anova wekuchiredzi ari kunzi Vurande Malupeko ndiye asenda etsamba kuConstitutional Court achimirirwa neconstitutional lawyer Professor Lovemore Madhuku panhau iyi. And tsamba iyi mukusendwa kwayo inauye kuti vari kuramba chiitiko chakaitwa musi 7 July 2026 apo pakawanikwa vaMnangagwa achisaina the Constitutional Amendment Bill number 3 into an act law mureZimbabwe, sezvo iko zvino Constitutional Amendment Act number 3 of 2026 kuti wakaiswa mutemo munyika yeZimbabwe. So now we yatenderedzwa ichiziviswa patsamba yanyorwa inova tsamba muri kuona takuisira pascreen apo iri kunzi Vuranda ndiye applicant, and the Parliament of Zimbabwe is first respondent, and President of the Republic of Zimbabwe is the second respondent, and the Attorney General of Zimbabwe is the third respondent, and the Minister of Justice is the fourth respondent. So paiswa vaziyambi pakaiswa Attorney General Virginia Mabiza and also President Emerson Mnangagwa, and Parliament of Zimbabwe zvichibatanidza vana Jacob Mdendane vese vari kuParliament vaendeserwa kucourt. So mumiriri ari kumirira apa ndi Professor Lovemore Madhuku anova ari kumirira kuopposition iyi NCA, and the NCA is a political party yake. So according to applicant under vari kutaura about under section 167(2)d of the Constitution of Zimbabwe 2013 as read with rule 32 of the Constitutional Court rule 2025 ndo manyorerwo ayaitwa inova iri tsamba yakaendeswa musi wa 18 July 2026 inova yaziviswa kuruzhinji rwenyika yeZimbabwe. So according to news maererano nechiitiko ichi, a fresh legal challenge have been filed at Zimbabwe Constitutional Court over recently enacted Constitution of Zimbabwe Amendment Act number 3 2026. The application was submitted by Vuranda, a Chiredzi East voter and member of the National Constitutional Assembly NCA National Executive Committee, who is represented by constitutional lawyer Professor Lovemore Madhuku. According to the court papers, Malupeko is asking the Constitutional Court to declare the entire Amendment Act null and void, and the applicant urged that both Parliament and President Emerson Mnangagwa did not fully their constitutional obligation during the process of passing and signing the legislation. The Amendment Act became a law after President Mnangagwa asserted to it on or around 7 July 2026. Before reaching the President, the bill had passed through Parliament, including the Senate, where it received 75 votes in favor and 4 against. This latest court application is reported to be one of the several constitutional challenges that have been filed against the amendment. However, unlikely some earlier cases that focused on specific section of the law, Malupeko's applicant asked the court to invalidate the entire constitutional amendment process and the act itself. One of the main arguments raised in the applicant concerned the constitutional requirement that proposed amendment must be published for public scrutiny before Parliament debate them. Malupeko urges that Parliament allegedly involved changes to several constitutional provisions that were not included in the original version of the bill that had been gazetted for public notice. The court papers list several constitutional sections that were allegedly changed after publication. According to the application, this denied the citizen an opportunity to fully examine and debate those proposed changes before they become law. The application also raised the concern about amendment affecting the judicial, and it urges that some of the changes could influence the structure of Zimbabwe courts and judicial appointment. Among the concerns highlighted in removal of the numerical limit on constitutional court judges, which the application say could have implication for judicial independence. These are arguments presented by applicant and remain matters for the court to determine. Another major issue raised related to constitutional term limit. Malupeko urges that extending the terms of the president and parliament from 5 years to 7 years directly benefit current office holders, and something he says is prohibited by section 328(7) of the Constitution. The applicant stated that because the changes allows current leadership to remain in office for an additional 2 years, and they amount to amendment that benefit sitting office holders. The court papers also challenged changes relating to presidential election. According to the applicant, the amendment changes both the method of electing the president from direct public voting to election by parliament sitting joint. Malupeko urges that this would affect citizen voting rights and other constitutional provisions without those sections being expressly amended. A further ground of challenge concerns that legislative process itself. The applicant alleged that Parliament failed to give the required public notice before the bill was sent to the President for assignment. According to affidavit, the public only become aware that the President has signed the bill after signed had already taken place. Applicant also said that because of the constitutional changes directly benefit the sitting President, President Emmerson Mnangagwa should not have personally assented to the bill. Instead, the applicant urged that an acting president should have signed it. This is one of the legal arguments now before the Constitutional Court. Malupeko is asking the court to decline that Parliament and the President failed to comply with their constitutional obligation and to rule the passage of the bill. The result act has no legal forces. Alternatively, if the court does not invalidate the entire act, the applicant asks that only the disputed provision be taken down. The applicant also is that the constitutional amendment should not be divided into acceptable and unacceptable section. Instead, it says a constitutional amendment should entire stand its entire or be declared invalid as a whole. The respondents are seated in the case are Parliament of Zimbabwe, President Emmerson Mnangagwa, and the Attorney General of Zimbabwe, and the Minister of Justice, Legal and Parliamentary Affairs. Under Constitutional Court rules, and the respondents have 21 days from the day they are served with the applicant to file any opposition papers if they chose to contest the cases. Muri Zimbabwe ndona wiri kubuda ndozo zvokutendera ndozo kuziviswa maererano nechitiko ichi munyika yedu yeZimbabwe. Munoti chi pamusoro pechitiko ichi? Ndidzo nhau dzatanga takabata pano pachannel yenyu, YouTube channel yenyu yaMagaba News.